It's about 9 minutes to 7 o'clock. Welcome back. Now, the Labour Appeal Court is urging employers to be more tolerant of employees' religious beliefs. This follows a successful appeal by an employee who was dismissed for refusing to work on a Saturday. Now, the Seventh-day Adventist was dismissed after stating that her religion prohibited her from working over the Sabbath, which is a Saturday, of course. Now, to explain this further, and just to unpack what this means for both employees and employers, we joined in the studio by Lovanya Moodley. She's Employment and Labour Associate at the Norton Rose Fulbright law firm. Lovanya, good morning. Thank you very much for coming through. Very important decision, this seems to be by the Labour Court appeal. Is this a precedent?
Yes, it is, Dan. It's a very important judgment, and it emphasizes the need for employers to exercise religious tolerance in the workplace.
Now, just tell us what happened, just without just delving back into the merits and the thing. What was the issue here?
The employee could not participate in a monthly stock take occasioned by her religious belief. She is a Seventh-day Adventist, and in terms of that religion, she's precluded from working on the Sabbath, which falls from sundown on a Friday to sundown on a Saturday.
Did she tell her employer during an interview that this is my religion and this is what it means?
According to the judgment, yes, she did in fact inform the employer of this during her interview, and as a result, she did not participate in any stock takes for a period of 12 months in the course of her employment.
And then they decided to terminate her employment, and she argued constructive dismissal based on her religious beliefs.
She argued that it was an automatically unfair dismissal based on her religious beliefs, despite the employer trying to classify her dismissal as an incapacity. Now, this is important.
So the employer tried to make this to be like an incapacity thing because she wouldn't do that monthly stock taking, which was against her religious beliefs.
Absolutely,
okay.
That is correct. But the court found that the true underlying reason for her dismissal was actually her religious belief, which precluded her from working on a Saturday.
Okay, what does this mean for employers? Let's start there. This is a precedent-setting kind of ruling by the Labour Court, and in terms of religious beliefs. What does it mean for employers then?
This judgment emphasizes that employers must not readily dismiss an employee for wanting to practice their religion. It emphasizes the need for religious tolerance and not to forget to reasonably accommodate the employee in the workplace when they have indicated that they cannot perform a particular function for a particular reason.
And after all, the Constitution in South Africa does give us religious freedom of religion.
Absolutely, Dan.
So you have to declare that. And then the employees, I mean, if I'm an employee, the lesson from here, if I'm reading this, is that I need to be upfront with my employer, so I'm not accused of taking advantage of certain religious things. I need to tell them in advance, this is my religious beliefs. Because sometimes employees, people can take chances.
Absolutely. Transparency is key. The employee in this case was very open from the stage of the interview, and she had informed the employer timeously and provided alternatives to her working on the Sabbath, which the employer failed to meaningfully consider. And that's another important point that employers need to take cognizance of. They must meaningfully and consider the alternatives proposed by the employees.
Just the incapacity issue, I'm fascinated by that. I mean, what would constitute incapacity in the Labour Court? What would be justifiable as incapacity?
Incapacity in South African employment law can be divided into incapacity for ill health or injury or poor work performance. Overall, it's the inability of an employee to perform his function.
So religious tolerance, number one. Incapacity as well. You can't just use it unless it follows what we have just described. Now, can then this ruling mean that there are reasonable grounds on which to be tolerant religiously?
Yes.
Can it mean that there are reasonable grounds to be tolerant?
Yes, absolutely. The judgment recognizes that our Constitution not only promotes diversity, but it encourages it. And it's quite a scathing judgment against the employer because it says that the employer failed to recognize how central this particular belief was to this employee.
Yeah, so this is a very, it's a tough lesson,
Yes.
but it's an important lesson. But we as employees as well need to be transparent and also need to act in a reasonable manner.
That's correct.
We cannot just, because of this ruling, suddenly come out with all kinds of religious beliefs that suit us when we need time out.
Yes, Dan, there must be a balance between the operational requirements of the employer, commercial rationale, and the right to exercise religious freedom.
Okay, thank you very much. Very clear there from Lovanya Moodley, Employment and Labour Associate at the Norton Rose Fulbright Law Firm.